Hello everyone, I'm Keshvanada Bharati and you're watching Conceptual Legal. We are live a minute before, so we'll wait for another 30 minutes before we actually start. We already have a host, we already have a speaker with us, but due to some technical issues, we are already live. So I'll just request you guys to please wait for another 10-20 seconds before we actually begin with the session. Thank you. Hello, everyone. We, as a law student, or I, as a law student, I remember whenever I had this Constitution of India in my hand, there were so many case laws which I think I had to memorize because I have to pen it down in my answer sheet to get good marks. But there was one case law which was always there throughout कि बिना सोचे समझे मैं इसको तो लिख ही सकती हूँ ये फिट हो ही जाएगा and that case law was none other than the Keshvananda Bharati judgment. We have seen the importance of that case law in almost all the articles of the Constitution of India because it's a historical judgment in itself. It's not only important for the judgment, for the fundamental rights part or for the amendments part, but it helps us to understand as to how exactly the law works, how it needs to be amended, what is the need of the society, and how the law need to keep a pace with the changing needs of the society so that it is able to do justice for the people for whom it is made. So, keeping that thought in mind, we thought of starting with our live session with Advocate Siddharth Sijoria talking about the constitutional amendment through special emphasis of Keshvananda Bharati judgment. We already have a speaker with us. So, we extend a very warm welcome to you and we are grateful that you took out some time and you are here for the session with us.
Thank you. Thank you for inviting me, Kushbu.
Okay. Sir is a graduate, 2015 graduate from Amity Law School, Noida. Sir has done. I'm so sorry. Just give me 1 second. The speaker for the session, Advocate Siddharth Sijoria, joined the Chamber of Constitutional Jurist, late Shri T.R Andhyarujina, as an associate lawyer in the year 2016. He was appointed by the Government of India, Government of Maharashtra to represent the state before the Krishna River Water Dispute Tribunal. In 2017, he attended Central European University, Budapest, to pursue a master's in cooperative constitutional law with a merit based scholarship. Sir has been practicing as an independent counsel before the Supreme Court of India and the High Court of Madhya Pradesh. In addition, Sir is also associated with Amity University, Lucknow as an adjunct faculty. With his vast experience in the constitutional matters and also his love for teaching, that is his academics experience. So I hope that the students or the participants will be able to learn a lot under your guidance during this session. So now over to you.
Thank you, Khushbu, for inviting me for this very interesting session. And you rightly start by noticing and that whenever we think of constitution, whatever chapter we are on or whatever we are reading, one thing that we always would have known is Keshvanada Bharati case, and not just about law students. If you meet anybody who's interested to study public administration or anything, Keshvanada Bharati has been one of the most important law in India, and we must all be proud for one thing, that most of the modern constitutions are adopting what we call basic structure theory today, and we were the first country and I was the first court to recognize the doctrine of implied limitation on amendment powers. So when we talk about amendments, we think what can an amendment means. Basically, when we talk that a constitutional amendment, it basically means changing the text of the constitution. And when we look at article 368, it talks about an amendment to the constitution can only be done by variation, repealing, addition of anything in the constitutional text. Now, when I like as to introduce everyone, article 368 is the constitutional Article 368 of the Constitution is the only article that deals with the amendment of the Constitution, and in itself is a chapter, and itself is a book, is in that it nothing goes beyond it where the power of the amendment to the Constitution can be found. So when I just can I just take you for a moment to the screen that I was sharing? If you don't mind, just a second. I hope I'm able to show you this screen and let me know if it is visible to you. Is it visible?
No, I don't think the screen is
Not
visible.
visible. Then let me just start by discussing that when we look at Article 368 of
Right.
the Constitution, it talks about amending the Constitution, and it provides basically three mechanisms to introduce the changes to the Constitution. So the first mechanism that we talk about when we look at Article 368 is the rule of special majority by which we can amend the Constitution. So basically, before I begin with what rule of special majority means, let me begin by telling you that our Constitution has many chapters. It has 24 parts. It has more than 395 articles, and every part of the Constitution is amenable to an amendment, but different set of rigidity or flexibility is attached to the article of the Constitution depending upon its importance to the existence of the Constitution itself. So, if we look at Article 368(2) of the Indian Constitution, it talks about two mechanisms by which we can amend the Constitution. The first one is the rule by special majority. So, now what is the rule by special majority? Basically means that a bill to amend the Constitution or any part of the Constitution can be introduced in the Parliament, and in order to get it passed, it has to be passed by each house by a majority of its total membership and a majority of not less than two-thirds of the member of the house who are present and voting. So basically, rule of special majority means that if an amendment is being proposed by any house of the parliament, then every member of the parliament must be present and he must be voting upon, and that amendment must be passed by at least two-thirds of the majority. So when as a law student, you must have got of hearing this word quorum. Quorum basically means that the minimum number of parliamentarians required to make a parliamentary sitting in order to facilitate the functioning of the parliament. But when you look at Article 368, it makes it mandatory that for a constitutional amendment to be passed, it must have every member of the house present and he must be voting at the same time. So this is the first mechanism under Article 368, which we call the rule of special majority. Then we look at there is another mechanism for the constitutional amendment, which means the amendment by way of uh, rule of state ratification. So basically, by its word, by its name, it's very clear that rule of state ratification basically means that there are certain provisions of the constitution, because India is a federal country. It has a union, then it has it has many state governments. So if there is a any amendment that is being introduced to the constitution, so as you know, Article 368 makes it mandatory that any provision of the constitution which for amendment can be introduced in parliament. So if parliament introduces any amendment to the constitution which also interjects or which also affects the rights of a state, that kind of amendment can only be passed only after taking consent of more than half of the state assemblies by resolution. So, in order, this is the second mechanism which is provided in the constitution. So, you can look at that special rule majority included that parliament must pass it, which was less rigid. But when we are amending certain portion of the constitution, like the appointment of the High Court or the Supreme Court judges or extent of executive power of the union, such mechanisms in the constitution that not only affect the union but also affect the state governments or the state assemblies, in that there is another layer of ratification which is included for making an amendment to be passed by the legislature. And once, if you use the rule by special majority or by state ratification, once the procedure is accepted and is facilitated, then the parliament would move the bill for amendment to the president, and when president will give its assent to the law, it will to the amendment bill, it will become a law. So now here I would like to take your attention to Article 368.3. Article 368.3, I read it as something that determines the nature of the amendment. What is the nature of amendment? Do we call amendment a law? Do we call amendment something different because it's a constitutional amendment? So we are at a threshold where we need to distinguish what it means. So then we must look at the language of Article 368.3. Article 368.3, if you have your law before you, you will read, and I will read it for your convenience. It basically means that nothing in Article 13 shall apply to any amendment made under this article. So this is very important aspect because this was entered into the constitution by an amendment to the constitution. So when I say that Article 368.3 is very important to understand the nature of constitutional amendment, it is because if you look at Article 13, Article 13 says that no amendment can be introduced or no law can be passed by the parliament or any state legislature that takes away or abridges any of the fundamental rights which are enshrined in Part 3. So when we look at Article 368, which says that Parliament can amend the Constitution, and when we look at Article 13, so there is a straight contradiction between the two. Because if Article 13 says that no amendment or no law can be passed which can take away the fundamental right, and then we look at 368, which says amendment can be done. So do we mean that Article 13 controls 368, and even a constitutional amendment by its definition being a law cannot violate fundamental right? So this was one of the important consideration when we come later at basic structure theory, but this was one of the most important aspects for understanding what Kesavananda was all about. Because I'll just give you one brief outlook before we begin, that it was in the case of Keshvanada Bharati only where the court said under law under Article 13 includes law enacted by exercise of legislative power. Constitutional amendment is made by exercise of constituent power. So here there is a distinction which is being drawn by the court, that there is a difference between the legislative power of the parliament and constituent power of the parliament. When parliament makes laws in its capacity as a parliament, when it is making any law for the subjects which are enshrined under Schedule 7, which distributes the powers between the state, center, and both in the concurrent list. So that is when Parliament makes law, that is with regard to the legislative power. But when amendment is being brought to any part of the Constitution, that amendment in itself is a exercise of constituent power not controlled by Article 13. So this is basically to give you a basic introduction about what amendment to the Constitution and what does the chapter or Article 368 signifies. So now, before we begin with basic structure theory, argue or explain you, there are two things that we must remember: that every constitution of the world, France, Italy, Indian, any other constitution, they talk about two types of limitations on the power of amendment. First is the express limitation. Second is the implied limitation. So express limitation basically means, if we look at the Constitution of France, it declares that liberty, equality, fraternity are inviolable, unamendable concepts of the French Constitution. Or we look at Italy or Benin, Colombia, many other constitutions says that some of the features are that cannot be violated even by amendment. And for making amendment to any of those provisions, the exercise of constituent assembly would be required, which means that the old constitution has to be replaced and new have to be brought in, where people will vote for the assembly for new constitution to be made. Second is implied limitation. When I call implied limitation basically means what India has done in the Keshvanada Bharati case. When there is no limitation on the power of the parliament to amend the constitution, but notwithstanding that, we introduced the idea of limitation by the very fact that parliament is itself a body which is created by the constitution. So parliament, by virtue of it being the creation of the constitution, does not or incorporate the power to destroy its creator, which is the constituent power. So this is the two basic differences. Now, this was the basic idea that I needed to explain to you before we begin with very interesting aspect of why basic structure theory was something that came into existence in India. So when India got its independence in 1947, India had its goal to become a socialist country. India wanted to make reforms to the laws in order to bring in more social upliftment for the people, for the society. And for that, we needed something which is very basic, the property. So we needed the properties to bring, we needed to acquire more property, we needed more land reformation during that time for in order to bring more changes or to in order to achieve the socialist aspirations that people had at that time. So when our constitution came into existence in 1950, we had Article 19(1)(f). Now, Article 19(1)(f) said right to property is also a part of fundamental rights. Now, when we say that Article 19(f) declares right to property is fundamental right, then this is one thing that you should keep in your mind. And now, when we look at the what happened after independence, so many state legislatures started making laws for acquiring properties, private properties of the citizens. They made several laws in the state assemblies, even for acquiring more property. And that laws were made in the exercise of the state legislature in the capacity of their legislative power. So this was basically done post independence. When we required more land, we passed more laws for acquiring more land. And once we were doing that, what I was doing as an individual whose land was being acquired, I moved to the high courts, to the Supreme Court, and I claimed that, look, Article 13 says no law can violate any of the fundamental rights. I have my vested right of property in Article 19(1)(f). So these laws are unconstitutional by the very virtue of Article 13. So the court looked at the provision Article 13, they looked at 19(1)(f), they looked at the law. The law was clearly in violation of 19(1)(f), which is the right to property. And the court declared the laws to be unconstitutional. So this was very pertinent right now because this acts the Congress party, who was also the government at that time, because they found this to be a major roadblock in the goals that they had for making India more, taking India to a more socialistic road. So, so what happened in 1951? We introduced the first amendment to the Constitution. Now, this was very important because the first amendment to the Constitution introduced something which I'm sure if you have read the constitutional law in the law schools, you must recognize that ninth schedule basically was introduced to make certain laws immune from judicial review. So what happened in 1951? First Amendment was introduced, and the First Amendment said that if any law is placed by the Parliament in the ninth schedule, a ninth schedule was added to the Constitution. So if any law is put in the ninth schedule by a constitutional amendment, that law will not be challenged in the court on the ground that it is violative of any of the fundamental rights, because the purpose of such a law is to achieve a directive principles enshrined under Article 39. So this was the first amendment, and as you know, Parliament enacted many laws, state assemblies enacted many laws, and those laws were being challenged before the court. But this time, when the Supreme Court was dealing with this case in a very important case law, which is the Shankari Prasad Deo versus Union of India, this was the first case where constitutionality of ninth schedule was challenged. And in this, the court, when it was hearing the challenge, it distinguished between Article 13 and 368. And the court, for the first time, said earlier laws which were declared unconstitutional by the courts were those which were laws made in the power of the assemblies or the state assemblies in the exercise of their legislative power. But what we have today is a constitutional amendment. And a constitutional amendment is not law, it's a constitutional law. And they distinguish the constitutional law with with legislative law by reading into by reading that when Parliament makes law under Article 13, it is the law for the purposes of when Parliament makes laws in the capacity of its legislative power, it is the law which will be subject to Article 13. But when Parliament enacts a law in furtherance of its constituent power under Article 368, it is not something to which court will have the jurisdiction to decide, because that is the constituent power. So this irked many constitutional scholars, this especially the people whose lands were being grabbed. And again, the parliament introduced another amendment with a similar motive, because that time even the word, there was also a debate about, okay, after the first amendment, that even if the parliament is acquiring or the states are acquiring the land of the private owners, then let us give them some marketable value for the property which is being taken. But this was also not allowed, because the word market value was not allowed, but only compensation was to be given by the parliament. So they introduced another amendment with a similar intent, that law can be introduced and put in the ninth schedule, and which will be again not amenable to judicial review. And that was also even upheld in the case of Sajjan Singh. Sajjan Singh versus State of Punjab was also a very important case, because this case dealt with the idea that, okay, constituent power is what amendment is created with, legislative power is what law is made, which is subject to Article 30. But this case is very important from the perspective that this was the first case where the idea of implied limitation was being discussed, that there can be implied limitation. And this was Justice Mudholkar in this case who first time said this, and I'll quote his words, that while he was a dissenting judge in Sajjan Singh along with Justice Hidayatullah, but what he said was that makers of the constitution would have sought to attach permanency to certain parts of the constitution, and he doubted if any change to the basic features could be made to the constitution by way of amendment. Or because if you allow an amendment which takes away the basic features of the constitution, then it is not an amendment, it is a replacement of the constitution with a new one. So this was also very interesting take of Justice Mudholkar in Sajjan Singh case. And for the first time, this was basic structure theory was discussed. After this, there was a very important case, and I'm sure as a law student, you must have read it, come to know of it. It is the case of Golaknath versus State of Punjab. Now, Golaknath was a very interesting case because Golaknath did undid to be sure, I mean to be precise, whatever happened before this. Golaknath clearly established that if you look at the Article 368, it's not the power. It does not say it's a chapter. Article 368 basically is the procedure. He said so because he said if Article 368 only provides for a procedure, the power lies somewhere else. He said that Article 368 is a procedure. Article 246, 245, and 248 that distributes the power between different states and the union, which is enshrined in Schedule 7, there the power to amendment can be found. So he did not found the power of amendment in Article 368, but he found in Article 248, which is the residuary power. But he said it for the reason that Article 258 says that Parliament, subject to the provisions of this Constitution, can make laws. So if the power to amend the Constitution is to be found in Article 245, and 245 starts with this, that subject to the Constitution, Parliament may have the law, power to make law. So Justice Subbarao in Golaknath clearly spelled out that Article 368 is only the procedure, power is under 245, 245 is subject to the Constitution, therefore the power which for amendment which is found in Article 245 is subject to Article 13. So what Golaknath simply did was it declared Article 13 as a controlling article of Article 368. So what Golaknath clearly said that fundamental rights cannot be amended by a constitutional amendment, and Article 13 controls what we all know is the power of the amendment or the procedure of the amendment. So this was, and look, and we have to understand this was the time when Indira Gandhi had come to the power, and she was known for her to act with her own wishes, and she was the one who acted, and she found this judgment to be a major roadblock, and this judgment was seen by her as a direct attack on her authority. So there were many other laws which were not passed, which were not allowed, which were the challenge of their constitutionality was upheld by the Constitution Court by using Golaknath case, and this irked Indira Gandhi very badly. And Indira Gandhi wanted to straight this judgment right. So what she did for that, she introduced 24, 25, 26, 29 amendment to the Constitution. So first thing that she did was, if you look at the marginal roads of Article 368, earlier before 1971, before this amendment was introduced, 25th Amendment, it said procedure to amend the Constitution. She replaced those words with the words power of amendment. So as I told you that in Golaknath this was read to be a procedure, she declared by this amendment that 368 is the power of the Parliament. And not only that, she introduced she introduced other sets of amendment also. I'll tell you that 24th Amendment, 25th, 26th, 29th, and 24th Amendment sought to overturn the verdict of the Golaknath by amending Article 368 and replacing the word procedure with power of the Parliament. 25th Amendment sought to introduce a new article, Article 31C, to the Constitution to insulate the review of the law placed in the 9th Schedule. 26th Amendment sought to abolish the privy purses, and 29th inserted other acts in 9th Schedule. So, just to give you a general outlook, this was how Keshvanada Bharati was brewing, because these were the amendment which was brought, and many people criticize that this is directly attacking the independence of the court. But looking at it, it seemed like she was trying to reclaim what it was thought that Parliament had. power to amend the constitution, and there were many reasons for that also. But so when basic structure case was argued, it was argued for very many long. It was argued for at least 66 days, and it's one of the most lengthiest judgment of the Supreme Court. But Supreme Court even upheld some of the amendment, and Supreme Court declared some of the amendment to be, I mean, the 26th amendment that introduced 31C, the second part of the amendment which made the review of certain laws to be, which insulated the judicial review of certain laws placed in ninth schedule, was also declared unconstitutional. But the court looked in basic structure case, the Keshvanada Bharati case, there, there, there was no clarity on the judgment. Like there were 13 judges, 7 judges favored implied limitation, 6 judges were not in favor of having any limitation on the constituent powers of the parliament, because they believe that every generation should decide for its own, and there should not be any kind of limitation to be placed upon the people's right to act through their parliament. And all these things were argued, but to make this matter very understandable for you, the court, I'll just quote some, one of the interesting judgments that must be read is the Justice Khanna, because this judgment had, as you all must have known, had its own political motives, because it was believed certain judges wanted to go against the judges, or certain judges wanted to go against the parliament power, and they wanted to uphold Golashnath case, and there were judges on the bench who wanted to uphold the parliament power, and there was only one judge, Justice H.R. Khanna, who discussed the power, who did not agree with Golaknath, but did not even favor the idea that parliament should have unbridled power to make changes to the constitution. Justice Khanna, one of the most important judges to be read to understand basic structure, he said that look, when we look at the constitution, we can definitely make sure that parliament, there is nothing in the constitution that provides that power of the parliament can be restricted. So this is a concept which was wrongly understood in Golashnath case. But he also said that if we look at the word amendment itself means that it should have the power to amend the constitution, but it said that it does not mean that you can replace its identity with a new one. So I'll just quote some of the things that he said. I'll just quote something that he said, that he emphasized the necessity of amending the constitution, as it was not possible for one generation to find a permanent working solutions for all the problems which might be faced by a state in future. He fully agreed with Burke, one of the philosophers, that a state without means of change is without the means of its conservation. Without such means, it might even risk the loss of that part of the constitution which it wished to most preserve. And he further said, however, according to him, the constitution can only be amended in such a way that as a result of the amendment, the old constitution survived without loss of its identity. He believed that so basically this was his idea, that you can amend the constitution, but you cannot amend the basic structure of the constitution. He said that every provision can be amended, and in such a manner that the basic structure of the constitution remained intact. Result of, and some of the examples of what basic structure is parliamentary form of government, democratic government, rule of law, secularism. And importantly, this list is not exhaustive but illustrative. And this is very important, because if I come to explain you each more than 1,000 pages, it will be very difficult. Even for me, it was a daunting task. But to understand what basic structure means, because I think when I was a law student, we read, okay, basic structure is something that is rule of law, supremacy of constitution, blah, blah, blah. These are some of the high sounding words. we invariably accept that constitution declares as inviolable. But I would suggest that if any of you are interested to understand what basic structure means, to understand basic structure would mean that look at the way you have survived all throughout your in your lifetime before after 1947. What has been what have been the things which have made your life more democratic, which have made your life more easy, with what are the things which have made the constitution a workable document, what are those provisions of the constitution that makes the constitution as an instrument of social change. If any amendment to the constitution is being brought in, you have to look whether that amendment seeks to destroy that particular feature of the constitution that have given you a right to lead a democratic life. For example, we look at this in 1990s when we looked at the judge's case, thus when the court said that primacy of the judiciary in appointment of the judges of the Supreme Court or the High Court should be with the judiciary because that is an important facet of judicial independence. In 1983, this thing made sense because that was a time when judges were being punished for going against the judge, for going against the government of that time. And that time it was felt that independence of judiciary is in danger because judiciary is being used to take out vengeance or the revenge of the government who felt the judiciary did not perform according to its whims and fancies. So that time, this must have thought this idea that okay, by doing certain act, judicial reviews, judicial independence is in danger. Then you invoke the idea that what an amendment, what a law is seen to be done to the constitution. And over the years, basic structure theory, basic structure doctrine has become one of the one of the features of the constitution, which has also become a facet of judicial review or a facet of judicial review standard. Because now we are seeing the judiciary has invoked the basic structure theory even in order to review the viruses of a statute when basic structure theory was initially seen to be a doctrine that can only be applied against the constitutional amendment. But with the growing times, basic structure doctrine has not only become a doctrine that is used only against amendment, but this is also being used against any offending uh, parliamentary act, any act that offends the very basic features of the constitution. So what is basic feature of the constitution will always depend on what an amendment is doing to the constitution. So now I think I'll end here and I'll let, if you have any questions, I'll ask Khushbu to please give me. And Khushbu, thank you very much for giving me
Right.
this platform to speak to
Thank you,
you.
Siddharth, for sharing so much of knowledge. As I was hearing, and you very rightly said that as a law student, we come across these terms as rule of law, basic structure, supremacy of law, these high terms, and
So
we feel that these are interchangeable, and we feel that these are the only important terms and these are probably interchangeable. So, according to you, like if you have to, in a minute, differentiate between these, how are you gonna do that?
see, every time it is a very pertinent question because when we look at amendment, now rule of law, what rule of law means is that everybody is equal. We go to the fairness very principle. We go to the idea of that everybody is equal before the law. And when we talk about separation of power, so if supposedly an amendment is being introduced, it's the cascading effect of an amendment of each of this idea. For example, you look at, for example, judicial independence. When judicial independence was challenged in the first judge's case, the idea was that look, this act will result in violation of the principle of judicial independence. But we see it is also violation of rule of law separation of power and other concepts, because separation of power, because judiciary is, as American jurisprudence calls it, like they do not have the power of sword or purses. So they have a more important power that they have to control the executive. But
Right.
if judiciary's independence is being violated, that invariably is also harming the principle of separation of power, because it will disturb the balance of power between authorities, and executive
Right.
would become more powerful. And it is very important in the Indian context, because in India there is no separate executive. It's only the
Hmm.
parliamentarians who also act in executive. So I think India had a very important duty to work and to India as Indian court, that they have to be very hard when they're judicially reviewing any of the acts of the parliament, because here they are dealing with two of the organs against one, with the executive and the parliament. So this is one of the
Right.
arguments.
And as you know, you're talking about the importance of judiciary, because when we talk about the constitution, when we talk about the law, we understand that law need to change. And when we talk about the procedure, the parliamentary procedure of enacting laws, the legislature, then we see that it's a bit, cumbersome, it's a bit time consuming. And then it's the judiciary which comes into picture. We have seen judiciary playing such an important role in framing new guidelines, whether it was the famous Vishakha case, wherein we didn't had any rules or laws or bylaws related to sexual harassment and workplace. And that's how the judiciary came into picture and laid down the guidelines and asked the legislature to enact laws. Not only that, there has been n number of instances. For example, the Navteej Singh Johar judgment, wherein they came forward, they repealed the law, and with the changing society, the judiciary has been very prominent. It has have a very important role in enactment of the laws and protection of the laws both. So when we talk about judiciary, there are certain terms which we see, such as judicial activism, judicial interpretation, and um, the role of judiciary. So, how, in this time, how are these terms, how is this role of judiciary changing? And what exactly you think this judicial impeachment, outranging their rules or their powers and interpreting the clauses, how far is it justified according to you?
So I think this is a very important question, because these questions have begun since 1980s, when the idea of PIL was introduced in the Indian Constitution, because that was also considered that this is the role of executive. So I think I would also recommend you a very important piece. Supposedly, when the judiciary crossed that Lakshman Rekha, that is what basically the question is. See, that is what now I'll give you. Firstly, I'll just say that there has been situations where judges have, like, you look at this, I can't remember the name of the cases, but I know there's a list of cases where the courts have entertained PILs or a writ petition for distribution of the petrol pumps between different people. There are these kinds of PILs which were entertained by the court. I can list you so many which I can't think of right now. So you have to look at the way that the when the court interjects. The interjection is for the upliftment of people who have been downtrodden and do not have the means to access the court, and the court is doing something in order to uphold it. But when you look at the court is trying to become the executive, for example, in Pakistan, I'll give you Pakistan, what happened? The Chief Justice started going on the roads, and he will stop by at a shop, and he'll ask the price of a particular good, and he will get enraged by that ki okay, the prices are inflamed or not. So the court's duty can be adjudged by the fact that whatever has been done by the court is whether for the upliftment of the people or the downtrodden one, or whether it's interference with the executive, because that is something very important, because we have looked all throughout. PIL was a mechanism which allowed people to come forward. We had judges like Bhagwati, we had judges like Krishna Iyer, who even entertained cases where dignity as a concept is very important to understand. like if you are being kept in a jail behind the wall. This is very dehumanizing. So these were
Right,
the things
right,
which were never discussed, but the court took a step ahead and they wanted to abolish the systems. This was the kind of judicial activism which was required. But we see today, like judiciary, whenever it enters the executive's shoes in order to think that it can do better what cannot be done, that is the problem. And I'll tell you, there's a book
right.
by an American author. It's called Judiciary Decree by Governance by Decrees. And there, that
Okay,
person, that author, he's teaching at Harvard or Yale. He makes a very important case that you look at the cases, number of cases where the court interjects and it brings out a very important judgment that does not have an effect on society, because you might look at a verdict the way it is being projected, but whether it has been able to achieve the purpose for which it was passed or not. So
right,
there you only have to see that you have to uphold the dignity of an individual, because India as a nation in 1947 wanted the constitution to be a document of social change. And I think India all throughout has suffered indignities, and judiciary's role must be there to uphold human dignity so that they can uplift themselves from the level of what they think of themselves to a level of citizen where they are subject to
right.
rights. This is what I feel.
Exactly.
That's
Yeah,
my
exactly. I totally agree with what you said. And in addition, like you just pointed out, you just referred a book, right? So since we have students who are listening to us, and the one very common and the most important question by a student is, "Ma'am, इस subject के लिए कोई book बता दो." So why don't you suggest some good books to our subscribers who for constitutional law? And in case if you can refer some authors who are good with some other subjects, you think that these are the books which a young lawyer or the aspiring advocate should read once to get some idea. So
I will just say कि if you want to understand how basic structure evolved in our country, I mean, I would say that my thesis got very good marks. So I would suggest that, if somebody is interested to study what basic structure theory means in India and how this has moved beyond India, I think I
right,
will share my thesis with you. You can share it with the students. And then there is a book by Mr. T.R. Andhyarujina, which is the untold story of the Keshvanada Bharati case, which is
okay.
one of the most telling book about the events that transpired when the hearing of this case was going on. So I think it will be very this if in order, and then you look at you read there's a book by Prashant Bhushan also. Then there's a book, but I think in today's time there's everything available online. So there is no need to read a book. There is nothing. You should read every case that have discussed basic structure and see from the very beginning at what impact that particular review would have had. Supposedly, read about this case, uh, uh, Indira Gandhi's case. Indira Gandhi's in election case. She made some changes to the
Right,
constitution, so that had a very different aspect. So every constitutional case which talked about basic structure, importantly, dealt the case in a very different scenario, because social history of the constitution was going into. So to understand these, I think you must read the cases and small commentaries on these cases on the internet. And I think if somebody is interested to know the gist, then I would highly recommend them to read my thesis, because it has been highly
Sir
reviewed also.
has already shared his thesis with us, and I'm gonna forward the same in the WhatsApp group, which in which all the participants are there. Also, Sir has shared up a write-up with us, a PPT also, which he wanted to use for the session. But then I requested him to speak up like that because I feel that's more convenient. I'm gonna share that PPT also with the participants in the WhatsApp group so that they can have a look with it. And in case the students have any queries, they may directly message us, and we will love to solve those queries even after the session gets over. Now, coming back to what we were talking about, uh, so you just pointed out some books. I hope the students might have noted it down and they may read it if they wish to and have some clarity on the topic. But you were just talking about judgments, like reading of judgments. Can you throw some light? Can you guide the students as to how exactly should we read a judgment? Because we know that judgments are very important for the students. They need to read it not only for the exam point of view, but also for their practical perspective. But the major problem lies that we have 700, 800 pages judgment. So, how exactly should a judgment be read? What is the rule of these commentaries and digest into students' life? How can they enlighten the student?
I think that's I have written for the convenience of the participants. I've shared the book's name on the chat. So if somebody is interested to understand what went during that time, they can read this book. Now coming back to the question, see the problem that
I'll
I
just clarify here the chat here belongs to you and me. It's a private chat. So
अच्छा
I'm gonna copy it and share it on the channel too.
comment
Okay,
हाँ
thank you.
और बात
Please
देखिए
continue.
हाँ तो बात when we look at the when I'm a like I love to read the judgment
Right.
from because I feel there are seen also that some because if you haven't read it no completely, you will always feel that something is missing. But that also depends on case to case, you know. I mean to so you have to understand when you're as a law student, you will be asked to mention that okay, tell me if you're reading this judgment, that judgment, what is the important thing that a judgment did. So there's always be something that the Keshvanada Bharati. It says basic structure theory came through Keshvanada Bharati case. But I think what we discussed today, in my experience as a law student, I did not have a teacher who explained it like that to me. That okay, there's a constituent law, there's a lawyer, legal law, and there's a different. So we only as a law student when I was a law student, basic structure to me was only basic structure that something cannot be amended. What are those things? Rule of law and all these things. This is how we understand law. But to have a overall understanding of such concepts, you must read from the commentaries. But there are certain when you're reading a judgment, read the issues which are being framed. Look, don't go just just go through the arguments, but definitely look at what the judge has said. Because I think when I was a learner myself, it was very hard for me to understand what is to be cited because even sometimes arguments are being referred to and sometimes you mistake argument to be the ratio of the case, but that is how so you I think you must have a keen eye on the judgments. You must have a very keen eye reading what the judges said, glance through the arguments, and if you are a law student, then basically you must read a good commentary. And good commentary in constitution I would say if you are inclined to read constitution, that you want to understand constitution, then H.M. Sirvai's book is the best to understand commentary on constitution. But if you want to pass the constitution, then judgments can be referred to like G.N. Pandey is there. It's a very good book because I think it can give you everything in that case. So so you have to maybe you have to tell yourself what you are interested in reading. Once you know that you like constitutional law and you want to read it, then make sure you have to read it. Because if you ask me, okay, there is this part of law, I would just want to read it clearly so that I understand. When I appear for my civil cases as a lawyer, I know that judgments are very small to the point. You find a particular paragraph, you refer to it because facts are different, everything is different. The law point is very similar. And today we have those case notes, head notes that help us in reading the law. But as a law student, again, commentaries are must. And if you find subjects, if you find a commentary that you love, then definitely read it in its entirety. And you have to, as a lawyer, you must be a reader. I mean, there is no shortcut to readings because if you read 10 paragraphs, miss three, and judge ask you a question which was a part of your judgment, forever you'll regret not reading those three paragraphs. So it's good to read judgments in its entirety. That's what I feel.
Right. And so there are few repeated questions by the participants, and one of them is how would you guide the students in the fourth year of their law course to steal their career in constitutional law?
Hmm. Very interesting. But it has to be made. I mean, see, you have to know that what are the career options you're looking at. I mean, this is basically a sport. Today's discussion was basically on the idea of basic structure. So this. I think this is very important that we restricted to that. But I think when you have someone who's asking this question out of curiosity, then I would say that you have to look what you are looking at. Basically, constitutional law in India badly has not developed, because if you look at other jurisdictions, they have constitutional divisions. Every country in the world has a constitutional ministry. So where there are a lot of job opportunities also for people who are interested in the study of constitutional law. Un- Unfortunately, in India, we don't have such things. We only have lawyers who are good readers who read law. Then you can do a judicial clerkship. But if you're interested, I think a PhD does make a difference. And if you want to go abroad, settle there, then you need to be very highly skilled in the research. But if you want to settle in India, then the options that if you want to make a career in a constitutional lawyer, then you have to start establishing yourself in the Human Rights Commission. You have to start establishing yourself in high courts, where you by yourself take up cases which are of constitutional importance. Because when I came back, I filed many cases where I tried to relate so many things that I've read. Because the problem that I feel is that every lawyer thinks that they know constitution because it's a fundamental right. Everybody looks at like that. I've met many people. There's no gain saying that people don't think like that, but many people would think like that. But if you definitely choose to make a career in constitutional law, you will realize that it's not that, and you would have a great advantage as a lawyer while arguing a case before high court, when you will add so many layers to an argument, because that is the constitutional law judgments run into more than 1,000 pages for a reason, because it's not simply like that, because you have tests and everything. Just what.
Thank you, sir, for enlightening us with so many information and knowledge. And it's time to wrap up now. It's time to say bye bye. So I hope we collaborate soon for another session. And it was great having you with us. Thank you so
Yes, it
much.
was so wonderful. Thank you.
Thank you.